May it please me, Lord, P. Ame, I appear for the defendant, sir.
Very well. Here's the judgment of the court.
As God pleases.
This is a suit commenced by general form of complaint dated 28 December 2022. The claimant commenced the suit against the defendant claiming the following reliefs. One, a declaration by this court that the wanton degree of injuries suffered by the claimant resulting while working as an employee of the defendant at the fabrication/welding department of the defendant. Two, an order of the Honorable Court awaiting the sum of 50 million naira, awarding the sum of 50 million naira compensation or damages for permanent incapacitation. Please mute your phone. Please. Yes, all of you should please mute your phone so that there won't be any interruption. So I will take the second relief again. An order of the Honorable Court awarding the sum of 50 million naira compensation or damages for permanent incapacitation, continual emotional and psychological trauma suffered by the claimant. Three, an order of the court awarding the sum of 516,000 naira as special damages to the claimant being the cost of medical treatment or drugs bought by the claimant from June 1st, 2022 to December 2022. Four, the sum of 5 million naira being the cost of this suit. And five, 30% interest quarterly on the judgment sum until final liquidation of the judgment sum by the defendant. It is the case of the claimant that he was employed by the defendant as a fabricator/welder. But sometimes in 2020, due to COVID-19 pandemic, there was a reduction in the staff strength of the defendant, which subjected him to rigorous work, both within and outside his department, which includes driving a tractor, working at the mining site, sweeping, and so on. That while picking sliced iron sheet at the fabrication welding factory on the 14th of March, upon the instruction of an officer of the defendant, one of the beams directly behind his back fell, thereby destroying the safety shoe on his leg, which caused an irredeemable damage to his leg. He averred that he was immediately rushed to the hospital, and pursuant to which he was taken to Obajana, where he was admitted. Further averred that while still receiving treatment, the defendant requested that he should be discharged and be brought back to Obajana for dressing, as he could always visit the Chinese colony doctor for routine dressing. Stated that as a result of working with legs for the said routine dressing, his legs started decaying internally, and upon his request and medical advice, he was returned back to the hospital after 4 months of lack of proper treatment, where he had skin grafting before he was again returned back to the Chinese doctor for dressing. That the defendant left him to personally fund for his treatment, and which treatment he funded through borrowing. And that the management has resolved to set aside the sum of 50 monthly for 3 months to take care of his bills, but which they did not. Was advised to resume work immediately, else he will be laid off, and he had no option but to resume as instructed. He later informed the defendant that his injury is deteriorating and he will need further treatment, but he was surprised to be informed that his service was no longer needed. And it is in respect of this that he has to take out this suit in court. The defendant filed statement of defense, and it averred that the claimant was employed under the mechanic workshop as a labor worker and a welder sometimes in 2019, and that it never reduced its work or its staff drastically as claimed by the claimant, but rather introduced semi-lockdown measures. And so the defendant never gave tractor to the claimant to drive. Just a minute. During the period, neither was the claimant deployed from the mining site. It averred that the claimant was the one operating the overhaul crane to shift 14 beams, another bench platform with expert welding, either welding other parts and some workers waiting to work on the H-beam already shifted in place. Stated that during lifting and shifting of the iron plate, after the claimant fixed the clamp on the iron plate, he didn't come down from the workbench to check if it was properly fixed before he started the overhead crane. It was as a result of the claimant's misoperation and violation of the safety operation regulation that caused the crane lifting cam to collide and got stuck with the iron beam, which led to the accident. He stated that claimant was taken to the hospital in Obajana for immediate attention to avoid losing too much blood, rather than sending him directly to Lokoja Hospital. It continued that contrary to the claimant's assertion, he was not satisfied with the said hospital. It made arrangement that he be referred to a specialist hospital in Lokoja, but that the claimant and his family members insisted he spend the night there before he was moved to Lokoja, where he was examined via X-ray, while it provided all the money needed for his treatment. And that it kept sending claimant back to the specialist hospital every 3 days for further treatment. About a month until the doctor suggested that if any clinic nurse was available, it could ask the local nurse to change medicine and bandage for the claimant within Obajana, which was done. It continued that the claimant claimed upon full recovery, he decided to resume on his own accord and was never subjected to any form of embarrassment, rather absorbed him into the company to keep working. Neither was he turned back from the gate, as he was allowed to drive its tractor, and he was doing so without any reduction in salary. It stated that the claimant recovered and resumed work. He was no longer showing seriousness to his job, hence the termination of his employment. On the 20th of June 2023, claimant opened his case, testified for himself as CW, and adopted his sworn deposition. He tendered documents admitted and marked as B to B7. Thereafter, the claimant was cross-examined and he closed his case. Subsequently, the defendant opened their case and they called 3 witnesses who testified on behalf of the defendant. They tendered 2 exhibits, Exhibit C and C1. Their witnesses were cross-examined by claimant counsel and they equally closed their case. At the close of trial, parties filed their respective final addresses. I've reduced the pertinent part of it into the body of this judgment. I'll go straight to the decision of the court. Upon a careful consideration of the processes filed by parties, the argument of counsel, and the authorities relied upon, it is in my respectful view that the issue for the just determination of this suit are whether the document tendered by parties, that is Exhibit B3, C and C1, are admissible in evidence. 2, whether the injury sustained by claimant is as a result of the negligence of the defendant in this case. And 3, whether claimant is entitled to the relief sought. Respecting issue 1, as regards the admissibility of pictures tendered by claimant, it is the contention of the Learned Defense Counsel, vide paragraphs 4.1 to 4.2 of his written address, that the pictures are inadmissible, having been made by claimant in anticipation of this case, in contravention of Section 83, subsection 3 of the Evidence Act. Section 83.3 of the Evidence Act, as amended, under which Learned Defense Counsel is raising his objection, admits twin conditions that must coexist, to which the statement in the document must be made by a person interested and during the pendency or anticipation of a proceeding. Section 83.3 of the Evidence Act specifically provides, and I quote, "Nothing in this section shall render admissible as evidence any statement made by a person interested at the time proceeding were pending or anticipated involving a dispute as to any fact which the statement might tend to establish," unquote. Section 83, subsection 4 goes further to define who a maker of a document is thus, I quote, "For the purpose of this section, a statement in the document shall not be deemed to have been made by a person unless the document or the material part thereof was written, made, or produced by him with his own hand, or was signed or initiated by him, or otherwise recognized by him in writing as one for the accuracy of which he is responsible," unquote. Courts have held that the above section was enacted to render inadmissible a document prepared by any interested person in order to defeat, through its clear wordings, the cause of justice. Such a document is rendered inadmissible when the maker knows about the pendency of the suit to which the document is made, and even where he does not know about the existence of the suit, he anticipated that a dispute might arise, then he deceitfully proceeds to make additional statement on the issues likely to be disputed or already in dispute with a view to reflecting the cause of a litigation in his favor on such issues. It is such craftiness and only such conduct that the provision of Section 83, subsection 3 of the Evidence Act seeks to prevent. See the case of Lokoja and Chemicals Industries and Services Limited and other citation captured. Section 83, subsection 3 applies to statements made in a document which tends to establish the fact in issue, which is clear from a community reading of Section 83.3. The court have held that the target of subsection 3 is not generally documents made while litigation is anticipated or pending, but only statements in documents made by any person interested in such litigation in which such statement might tend to establish the facts in dispute in litigation. See the case of Dung and UBA Limited citation captured. It needs to be pointed out that when interpreting a law, the responsibility of anyone interpreting it is to find out the intention of the lawmaker, which can only be discovered from the words used. See the case of PDP and Sarol and other citation provided. The words quote and unquote statement and quote and unquote tending to establish inserted in Section 83, subsection 3 of the Evidence Act are not there as surplusage. After all, it is the principle of interpretation that lawmakers do not use words in vain, nor indulge in tautology or in surplusage. It follows, therefore, that every word in a statute must be constructed and given effect to. See the case of Dung and UBA Supra, Babajo and another versus Bawa and others, Orubu and INEC, Tukol and Governor of Gongola State, all citation captured. I do not think the pictures come within the contemplation of the word quote and unquote statements in Section 83.3 of the Evidence Act. On the flip side, the pictures only captured the gory side of the injury sustained by claimant while working for the defendant and the aftermath of his said injury on claimant, which makes the pictures very relevant and admissible in this action, founded on negligence. After all, relevance is the hallmark of admissibility. Put differently, the pictures are admissible for the purpose of supporting claimant's contention that he sustained an injury in the course of work, which injury has left him with some form of permanent scar. In any case, there's nothing in this case to infer that claimants even snapped the pictures in anticipation of this action. At any rate, it is noteworthy that the said pictures that make up Exhibit B3 were tendered and admitted without any objection from the defendant on the 20th of June 2023. The position of the law is that generally an objection to admissibility of a document should be made at the time the document is being tendered. In other words, the proper time to object to admissibility of a document is when it is being tendered. See Ogunbodede and FRN citation captures, Sunday and the state citation provided, Dawu and the state, Oguntayo versus Adelaide and other citation provided. However, nothing precludes a party from raising an objection to a document if the document is by law in itself inadmissible in all circumstances, and such document cannot be acted upon by the court, even if admitted without objection. In essence, when the admissibility of the document is subject to certain conditions, the party objecting thereto must raise the objection timeously. Otherwise, he's stopped from raising same later. See the case of Kazim and the state, Osho and Akbe citation provided. The said documents being pictures are admissible subject to fulfillment of the conditions in Section 84 of the Evidence Act, which the claimant validly complied with. It is even late in the day for counsel who did not object to the admissibility of the pictures to now be raising same in his address. This is more as the documents not legally inadmissible under any circumstance. It is in view of all the reasoning above that I find that the pictures that make up Exhibit B3 are admissible in law. Those I discountenance with the defendant's objection to Exhibit B3 and resolve this in favor of the claimant. In the same vein, learned claimant counsel during trial objected to some documents tendered by the defendant as Exhibit C and C1. Counsel submitted that the receipt that make up Exhibit C, that is receipt numbers 178 dated 18th of August 2022, 0150 dated 11th March 2022, 1232 dated 18th June 2022, 1220 dated 18th of May 2022, 154 dated 10th of April 2022, 1231 dated 14th June 2022 have no customer name and signature on them. In the same vein, receipt dated 28th of March 2022 has no name on it, while receipts from Godswill Pharmaceutical Limited dated 2nd of June 2022, 31st of May 2022, 7th of June 2022, and 14th of June 2022 have no customer signatures and name on them. As rightly submitted by learned claimant counsel, an unsigned document is a worthless piece of paper with no efficacy in law. Thus, it is inadmissible, and where admitted, it cannot be relied upon by the court to resolve any controversy between parties, as no weight or probative value can be attached to same. See the case of Kachala and Haman and another citation captured, Maku and Almakura and others, Jinadu and Esoro Biaro, Omega Bank and OBC citation provided. The pertinent question is, are these documents unsigned to be inadmissible? I peruse all these documents and I find that there is no receipt number 1798 dated 18th August 2022 as part of a bundle of receipt in Exhibit C, as learned counsel will want this court to believe. Rather, receipt number 1798 that is in the bundle of receipt is dated 31st of March 2022. Also, receipt dated 28th of March 2022, contrary to counsel's position, has the name of a customer which is claimant's name on it, with the signature of the manager of the medicine shop, though the signature of the claimant is not on it. In the same vein, receipt number 0150 in the bundle of receipt in Exhibit C is dated 11th of May 2022 as against 11th of March 2022, which counsel submitted as the date of the receipt. It is equally clear from a perusal of a said exhibit that receipt dated 10th of April 2022, which counsel also objected to, does not have any receipt number, not to talk of 154. In any case, although the name portion of the receipt is blank, claimant's name is found on the lower part of the receipt, though the name was written on a different date as seen from the document. However, there is no receipt number 1232 dated 18th of June 2022, number 1231 dated 14th June 2022, and any Godswill Pharmaceutical Limited receipt dated 2nd of June 2022, 31st of May 2022, 7th of June 2022, 14th of June 2022, among the bundle of receipt tendered as Exhibit C. And it leaves one to wonder where counsel got the receipt numbers and name of pharmacy and dates from. In any case, one fact stands sure from the receipt number 1798 dated 31st of March 2022, number 0150 dated 11th May 2022, number 1220 dated 18th May 2022, receipt dated 28th March 2022, receipt dated 10th of April 2022, tendered from different pharmacies or medicine stores as part of Exhibit C. And that is the fact that even though some do not have the customer's name, they bear the name of the pharmacy that sold the drugs or medical supplies and the signature of the person in charge of the pharmacy. It needs to be stated here that the essence of the signature on the document is to authenticate it to the effect that it is the mark of the person who prepared it. See the case of Enali Moore and Elodumore citation captured. Ade Farasi and Dayek, citation provided. Salibawa and Habiba, citation provided. Since the signatures of the officers in charge of the pharmacy and the pharmacies who afford the receipt on those receipts are admissible. The name and signature of the customer is not needed for admissibility of those receipts because the customer could not have been the maker of the receipts. The question whether those receipts have any evidential value in view of the fact that they do not bear anything relating to claimant is another issue entirely, which comes after the said receipts have been admitted. In another leg of his objection, he submitted that the receipt of the specialty hospital, Lokoja, which is part of a bundle of documents marked as Exhibit C, are computer-generated evidence that ought to comply with the provisions of Section 84 of the Evidence Act. The Supreme Court, in the case of Attorney General of the Federation, Anu Ebunwa, citation provided, Ogumiju JSC at page 270, paragraphs F and G to H, held that a statement of account is a computer-generated evidence in line with Section 84 of the Evidence Act because it is the algorithm stored in the database of the bank that produces the statement. The Apex Court in the above case also emphatically held that the mere fact that a document is typed using a computer does not make it a computer-generated evidence, but what makes a document computer-generated is information stored on the computer, because according to the Court, Section 84 of the Evidence Act intends that only complex evidence generated from the computer against which the calculating or measuring accuracy of the computer is dependent upon or stands to be tested is to be subjected to scrutiny by the courts and not ordinary documents printed out of the computer. I peruse Exhibit C and find the receipts are not any form of complex evidence on which the calculating or measuring accuracy of the computer is dependent upon or stands to be tested for this court to refer to them as computer-generated evidence. I do not agree that the receipts are computer-generated evidence requiring compliance with Section 84 of the Evidence Act. In the same light, counsel equally objected to Exhibit C1, which is a document titled Settlement of My Left Foot Heel Injury, unquote. On the ground that the document was not addressed to anybody and thus not connected to this suit, and that assuming it was addressed to the defendant's signature ought not to be on it, and that a single party cannot execute an agreement. He equally objected to the said document on the ground that it was not signed, and assuming it was signed, signature and thumbprint cannot be used to execute a document at the same time. First, let me say that the bedrock of admissibility is relevancy and is governed by the Evidence Act and the pleadings of parties. See Diverse Asset Management Limited and Others in Wema Bank PLC is a 2023 Apex Court decision, Honorable Commissioner, Ministry of Lands and Survey, Makurdi and another, citation captured. The case of Main Street Bank Registers Limited and Ukandu, citation provided. Once a document is relevant, it is admissible. The question of probative value is a different issue entirely. See the decision of Apex Court in the case of Ondoka and Obot. Ondoka versus Obot and another, citation captured. Abubakar and Chooks, citation provided. Exhibit C1 was pleaded at paragraph 43 of the statement of defense, and it relates to the injury in this case. The question is whether or not it was addressed to anyone, or whether the defendant's signature ought to be on it, or whether signature and thumbprint can be used to execute a document at the same time, are not questions of admissibility, but questions of probative value or weight to attach to the said document, which is a matter of law, tainted with some fact. Besides, the submission that the document falls short of an agreement because a single party cannot execute an agreement is equally not a question of admissibility. As regards the contention that the document was not signed, it is admitted that an unsigned document is not admissible in law. As document that is not signed has no maker, and such a document is worthless, as I've stated earlier, and thus inadmissible in law. See again the case of Kachala and Haman and another Supra, Maku and Al-Makura and others Supra, cite Benjamin and PDP and other citation captured. I perused the said document and I saw a name that looks like a signature and also a thumbprint on it. The thumbprint alone is not enough as signature, so it cannot be said that the document was not signed. Sorry, let me take this again. The thumbprint alone is enough as signature, so it cannot be said that the document was not signed. I say this in view of the fact that the Apex Court pen Guta JSC of blessed memory, in the case of Agbola and the state citation provided, emphatically stated the position of the law on thumbprint does, and I quote, "A thumb impression authenticates a document as much as a signature does. It has been stated that exactly what constitutes a signature has never been reduced to a judicial formula, but it has usually been regarded that whatever is intended as a signature is valid signing, no matter how imperfect or unfinished or fantastic or illegible or even false the separate characters or symbols used may be," unquote. Whether the signature or the thumbprint is that of the claimant is a different thing entirely that relates to the probative value or weight to attach to the said document, and which I will consider in the later part of this judgment. It is in view of the above that I discounted as the objection of learned claimant counsel to the admissibility of Exhibit C and C1. Having resolved the question of admissibility of documents before the court, I now turn to the merits of this case. It is clear from the relief sought and the issues raised by parties that what this court is called to resolve is whether or not the defendant was negligent towards the claimant in a way which resulted into claimant's injuries. It is when this question is resolved in the affirmative that the court will resolve the issue whether the claimant is thus entitled to damages and all other relief sought in this case. I am mindful of the fact that claimant did not specifically plead negligence in his pleadings. In the case of Afra Chem Limited and Owodwenye, citation provided, where a similar thing happened, the court pen Wambai JCA held us, and I quote, "Admittedly, the respondent did not plead the word quote and unquote negligence in his pleadings at the lower court. However, at common law, as it is in our law, an employee may sue his employer for compensation, either in tort or in contract, and may choose to do so in contract where there are other advantages. One of such instances could be where an injury is suffered by an employee at work. Such an employee may bring an action against the employer either in tort or in contract. The case of Matthew versus Kuwait Beck Telecom Corporation was cited, unquote. In fact, this court in the case of Anil Fiok, Akpan Udo, and Alibet Products Nigeria Limited is an unreported suit number NICS/ABJ/08/2023, which judgment was delivered on 29th of February 2024. I held us, and I quote, "It is the contention of learned defense counsel on behalf of the defendants in its final written address that claimant in the instant case failed to give particulars of negligence as required by law, and which failure, according to him, is fatal to claimant's case. Taking the pleadings of the claimant into consideration, it is clear that the complaint of the claimant borders on the negligence of the defendant from when the defendant failed to give him safety kit and other protective kits, and his failure to replace the faulty foaming machine, up to the alleged refusal of the defendant to willfully settle claimant's medical bills and alleged refusal to ensure proper medical care for the claimant. Paragraphs 4 to 13 of the statement of facts clearly show this fact, which in my view are sufficient particulars of the alleged negligence. The mere fact that claimant did not title them, quote, particulars of negligence, unquote, in order to show that he was particularizing them does not detract from the fact that they are sufficient particulars of the negligence. See the decision of this court in Babatunde Ajala and Wright Park Limited on reported suit number NICS/LA/432/2013, a judgment delivered on 28 January 2019 at paragraph 38 thereof. If the court accedes to the position of learned defense counsel and says that because claimant did not title those facts as particulars of negligence, he has not given particulars of the negligence alleged, it will mean that the court is entrenching technicality over substantial justice, which the courts have shifted from. See the case of Access Bank and Sunshine Oil and Chemical Development Company Limited, case of Lokoja and Adeleke and others. Whether claimant led evidence in proof of the alleged facts of negligence is another issue entirely, unquote. It is deducible from the above authorities that even though an employee does not particularly plead negligence or even use the word negligence in his pleadings, once the facts pleaded are properly suited under the tort of negligence and are sufficient that will suffice. The claimant in this case no doubt brought this case under the tort of negligence, even though he did not specifically use the word quote and unquote negligence or specifically in a particularized same in his pleadings, because the facts pleaded are properly suited and are sufficient particulars required for an action under the tort of negligence. The case of UTB Nigeria versus Zoemena, citation captured, defined negligence as, I quote, lack of proper care and attention, careless behavior or conduct, state of mind, which is opposed to intention, the breach of a duty of care imposed by common law and statute, resulting in damage to the complainant. And the same vein, the court in the case of Iferi versus True Foods defined negligence as, quote, the omission to do something which a reasonable man, guided upon the consideration which ordinarily regulates the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do, unquote. See also the case of FBN PLC versus Ibena, citation provided, Odinaka and Mongalu, citation provided, UBA Limited and Akoru, citation provided. First, it must be pointed out that in order for a claimant to succeed in an action for negligence, claimant must prove that the defendant owed him a duty of care, that the duty was breached, and that the breach resulted into an injury or damage. See the case of ANTS versus Atoloye, citation provided. Negligence is complete and actionable when these conditions are met. See the case of Boju's Nigeria Limited and Marine Services Limited, citation provided. In the case of MTN Nigeria Communication Limited and Abdullahi and another, citation provided, Gomel JC held on how to establish the existence of duty of care thus, and I quote, the Supreme Court in the case of IMNL versus Nwachuku gave a guide on how to establish the existence of duty of care, where it stated thus, the recent decision of the House of Lords has summed up the law admirably in Anne versus Meton, London Borough Council, where Lord Wilberforce stated as follows, through the trilogy in this house, Donoghue and Stevenson, Headley, Bayern and Company Limited versus Hele Partners Limited, Dorset Yacht Company Limited and Home Office, the position has now been reached that in order to establish that a duty of care arises in a particular situation, it is not necessary to bring the facts of that situation within those previous situations in which a duty of care has been held to exist. First, one has to ask, as between the alleged wrongdoer and the person who has suffered damage, if there is a sufficient relationship of proximity or neighborhood such that in the reasonable contemplation of a former, carelessness on his part may be likely to cause damage to the latter, in which case a prima facie duty of care arises, unquote. Parties in this case are evident that claimant was an employee of a defendant. An employer like the defendant owes its employee a duty of care, and which duty is both statutory under the Factories Act as well as under common law. See the case of MTN Nigeria Communication Limited and Abdullahi and another Supra. The case of Green Park Rubber Industries Limited on the side, citation provided, Aditon and Idiot, citation captured. The Court of Appeal in the case of Bello and Dada and another, citation provided, Sankey JSC, now GSC, held that generally in law, where there exists a service relationship between employer and employee, the former is under a duty to take reasonable care for the actions and safety of the latter in all the circumstances of the case, so as not to cause harm to others or to expose him, that is the employee, to unnecessary risk. See also the case of Yeri and Bendel Feed and Flour Mills Limited, citation provided. By the decision in the Nigerian case of IITA and Amrani, citation captured, where the court held that a master's duty towards his servant is to see that reasonable care is taken of the employee, and this duty extends to provision of safe equipment, safe fellow employees, safe place and system of work. It is not in doubt from the above authorities that the defendant owed the claimant a duty of care as its employer. Thus, claimant has established that the defendant owed him a duty of care which arises by virtue of the employment relationship. Just a minute, please, learned counsel. I need to do something to the to the gen, please.
That's called please.
Yeah, I ain't taking.
Sorry, I'm back, please. I would continue. The next hurdle for the claimant to fulfill is to determine whether the defendant breached the above duty of care. Claimant alleged that when he was ordered in the fabrication or welding factory of a defendant to pick up sliced iron sheet by an officer of the defendant, the beam that has been improperly arranged by some other employees of the defendant fell and damaged the safety shoes on his legs, which caused irredeemable damages to his leg. Thus, it is clear that claimant is alleging that it was the act of the defendant's employees who negligently arranged the beams that caused the injury to him. The defendant, on its own part, refuted the above and averred at paragraph 16 to 18 of his statement of defense that the claimant was the one operating the overhead crane to shift the beams and other materials over the steel plate pad on top of a high work bench or platform, with expert workers working on other parts of weight. And as such, the iron sheet is weighty and cannot be picked up by anyone, in contrast with claimant's assertion that claimant, during the lifting and shifting of the iron plate after fixing the clamp, did not come from the workbench to see if the clamp was properly fixed before he started the overhead crane, that he was standing on the platform with his back to the iron plate being lifted and shifted, and as such, the injury was caused to claimant due to his own misoperation and violation of the safety operation regulation that caused the crane lifting the clamp to collide and got stuck with the iron beam and turned over on claimant's heel, leading to his injury. In proof of these facts, the defendant called DW1 one Ada Ehechofu, alleged to be a co-employee of claimant, and DW2 one Chigozie Desmond. Claimant, in response, viewed paragraph 13 of his reply to the statement of defense, avers that the contention of the defendant is false, as no laborer worked without strict constructions and supervision, and no superior officer would watch a laborer misbehave against the ethics of the Chinese work environment. And if he had sustained any injury on his frolic, the defendant will never hesitate to disengage him immediately with or without treatment, and that the defendant is put to the strictest proof. DW1 has stated in paragraph 12 of his statement on oath, which was already adopted as his oral evidence, that he and claimant and other staff were working at the mechanic workshop on the 15th of March 2022 when the accident happened, which presupposes that he was at the scene of accident. Under cross-examination, he was asked if he had anything to show that he was employed by the defendant. He answered no. He was equally asked that the accident occurred at the place he mentioned. He answered that the proof is in the headquarters of the defendant. One would then begin to wonder what he was doing in court without such proof, which he stated was in the headquarters and which he has not brought to court. In the same vein, DW2, when asked if he has a safety operation regulation which claimant allegedly breached in court, he said he does not have that in court. Again, one would wonder how the defendant wants to prove that there was in fact a safety operation regulation that claimant allegedly breached, which led to his injury. Also, DW2 affirmed under cross-examination that he was not at the scene of the accident. Since DW2 was not at the scene of the accident, he will not know what transpired there. Besides, the quality of claimant's evidence will be weightier than that of DW2, who was not at the scene of the accident, and as such, not a direct witness to the issue. See the decisions of this court. In the case of Babatunde Ajala and Right Park Company Limited Supra, Dorothy Adaizi Awogu versus TFG Real Estate Limited on reported suit number NICS/LA/262/2013, judgment delivered on 4 June 2018, Mr. Charles Ugeli and Access Bank PLC on reported suit number NICS/LA/287/2014, a judgment that was delivered on the 10th of February 2017, and the case of Pastor Mrs. Abimbola Patricia Yakubu and Financial Reporting Council of Nigeria and order on reported suit number NICS/LA/673/2013, a judgment that was delivered on the 24th of November 2016. DW1, who is alleged to be a co-employee of the claimant who had said he was at the scene of the accident, does not have any evidence in court to show that he was a co-employee of claimant. Does not equally have any evidence in court to show that the accident happened at the place he narrated. This makes his evidence less weightier and unreliable when compared with that of claimant, who is the complainant and the direct victim. Besides, claimant has refuted the above allegations of the defendant in paragraphs 12 and 13 of his reply to the defense. In fact, by paragraph 13 of his additional sworn deposition, he stated that he never failed to follow the company's safety procedure, and that as a matter of fact, he was on his safety shoes when his leg was badly damaged. Claimant during cross-examination was never cross-examined as to the above material fact, refuting the defendant's allegation that he breached safety regulations leading to the injury. The law is clear as to the effect of failure of a party to cross-examine his adversary on a material point, which the law takes as a tacit acceptance of the truth of the evidence of a witness on that point. See the case of Shegwan, the state citation captured, Cameroon Airlines and Ututuizu citation provided, Gaji and Kwaye citation provided. The defendant ought to cross-examine claimant on the above point or show that his testimony in that regard is untrue. Whereas in this instance, neither was done, the court would readily conclude that the defendant does not dispute the fact that fact. In view of all the above reasoning, this court is compelled to believe the account of claimant as to how he sustained the injury. As reason supra, claimant's account shows that the injury was caused to him when he was ordered in the fabrication or welding factory of the defendant to pick up sliced iron sheets by an officer of the defendant. The beam that has been improperly arranged by some other employees of the defendant fell and damaged the safety shoes on his leg, which caused irredeemably damages to his leg. I'm mindful of the fact that case law authority says where a co-employee injures another employee who is in common employment with him, the employer will not be liable. See the case of Nigeria Tobacco Limited and Abunani. This is usually referred to as the doctrine of common employment. It is worthy of note that in Nigeria, statutory authority says otherwise. The Labor Act, Cap L1, Laws of Federation 2004, which is the basic law governing labor and employment in Nigeria, operates against the doctrine of common employment, which seeks to absolve an employer from liability caused an employee by a co-employee. By Section 12 of the Labor Act, an employer, that is the company, can be held liable in negligence for the injury caused by a co-employee to another employee of the company. This provision of the law, that is the Labor Act, supersedes the common law position that absolves an employer from liability from any accident or injury caused by negligence of its servants in the course of employment. See also the case of Babatunde Ajala and Right Park Company Limited Supra. Besides, it is the duty of an employer to provide competent staff in such a way that where an employee is by his conduct likely to pose danger to other employees, an employer is duty-bound to remove such source of danger. See the English case of Hudson and Rich Manufacturing Company Limited citation provided. This duty includes the duty of effective supervision, proper and safe workplace. See the English case of Wilson and Clyde Cole versus English citation captured. In the above case of Hudson and Rich Manufacturing Company Limited, Supra, the claimant was an employee of a defendant injured in the course of the work as a result of prank from a co-employee, and which co-employee the defendant knows of having a reputation with such pranks. The issue arose whether an employer owes a duty of care to ensure that the workplace was safe and that other employees' conduct do not pose risk or harm. It was held that the employer was under a duty to ensure that risks are prevented at workplace. Thus, in deserving circumstances, an employer may be held liable for acts of his employee which causes harm to a fellow employee. In my humble view, the defendant will be held to be vicariously liable for the negligence of its other employee who negligently placed the bills which injured claimant. At any rate, assuming the position of the defendant that claimant's injury was caused due to his misoperation, violation of the safety operation regulation is even true. Same cannot stand in the light of the decision in the case of Wilson and Clyde Cole Limited and English Supra, where the House of Lords held that it is the duty of an employer to provide a safe system of work which is personal to the employer and as such cannot delegate in such a way to absolve him from liability. Thus, even if the employer had delegated the duty to another person, it still remains accountable for workplace safety. In that case, the employee, while in the course of his employment, was crushed down by a haulage plant and died from injuries sustained, and his family brought an action against the defendant. The defendant, in its own defense, contended that the employee contributed to his own death because he should have told the person in charge of the machinery that he wanted to go the pit button, or he should have taken an alternative route. The House of Lords, in its unanimous decision, held that an employer's duty to provide a safe workplace and safe work system is non-delegable, and where such duty is delegated, same would not absolve an employer of liability. See also the English case of Smith and others FC versus the Ministry of Defense citation provided. Similarly, the above defense of the defendant is not tenable in view of the decision in Green Park Rubber Industries Limited on Osai Supra, wherein the court held that by Section 23 of Factories Act, no person should be employed at any machine or in any process being a machine or a process liable to cause bodily injury unless he has been fully instructed as to the dangers likely to arise in connection therewith and the precautions to be observed, or is under adequate supervision by a person who has a thorough knowledge and experience of the machine or process. The case went on to lay down the principle that when the statutory duty is imposed on an employer, but not on the employee or workman who is injured, and there is a breach of that duty, which breach resulted in an accident to the employee or workman, the employer will be liable subject to an apportionment for contributory negligence. Thus, the employer would be completely exonerated if the workman, after being given appropriate equipment and instructions, disobeyed those instructions or did some other deliberate wrongful act which breaks the causal connection. See also the English case of Yorkshire Traction Company versus Walter CB citation provided, where the Court of Appeal of England held that the employer's duty to provide safe workplace includes all equipment and machinery and duty to maintain the equipment and provide strict instructions on how to use it. DW1, a co-employer of the claimant in paragraphs 16, 17, and 18 of his written deposition, averred that claimant was standing on the platform with his back to the iron plate. He was lifting and shifting, and that it was as a result of the claimant's misoperation and violation of the safety operation regulation that caused the crane lifting clamp to collide and got stuck with the iron beam, which turned over on his heels, leading to the accident. And also that claimant was not standing in the right place where he ought to stand, and he has his earpiece listening to music against his advice. He continued in paragraphs 19 and 22 that claimant was not fully concentrating on the job, also with his back to the material he was lifting. That was how he got his heel injured instead of his forefoot, and that the beam can only be placed through the help of a crane, which was operated by claimant, and it was the failure of the claimant to observe safety procedure by listening to music on his headphone and not concentrating on the job that led to the accident. Section 26, subsection 8 of the Factories Act provides us, and I quote, as regards lifting of machine, a lifting machine shall not be operated except by a person trained and competent to operate that machine, except that it shall be permissible for such machine to be operated by a person who is under the direct supervision of a qualified person for the purpose of training, and no person under 18 years of age shall be employed to operate any lifting machine driven by mechanical power to give signals to the operator of any such machine, unquote. Subsection 9 thereof defines lifting machine thus, I quote, in this section, the expression lifting machine means a crane, crab, winch, tiggle, pulley, block, chain wheel, transporter, or runway, unquote. It therefore means that the crane which claimant was allegedly operating according to the defendant is a lifting machine. By the combined effect of section 26, 8, and 9 of the Factories Act captured above, claimant must operate the crane only if he is sufficiently trained, and where he is not trained, he shall operate such under the direct supervision of a qualified person for the purpose of training. There is nothing put forward by the defendant to show that claimant was sufficiently trained on how to use the alleged crane, or that as an alternative, he was working under the supervision of a qualified person for the purpose of training. This is a breach of a defendant's statutory duty of care, as provided in section 26(8) of the Factories Act. In the case of Ajao and Western Nigeria Trading Company Limited, citation provided, the court held that pursuant to an employer's duty of safety, an employer is under an obligation not only to provide safety devices, but also to give strict instructions followed by supervision in order to ensure that the employee adheres in the course of employment. The court in that case held that the duty of the employer at common law is not only to provide safety goggles, but also to ensure that they are used by the employee. In like manner, in the instant case, it is not enough for the defendant to show that claimant breached safety rules. It has to show that it gave strict instructions and supervision to claimant to ensure he complied with those safety measures, and that despite this, claimant still breached the safety rules. Assuming the depositions are even true, if the defendant had properly supervised claimant, claimant would not have been able to breach or violate any safety operation regulation. DW1 in his written statement on note has stated in paragraph 10 thereof that one Mr. Lee, who claimant alleged to be the one who asked him to go to the factory, was the Chinese mechanic supervisor. There's nothing before this court to show that claimant was even properly supervised by the said Chinese supervisor, Mr. Lee. Where was the alleged supervisor, Lee, when claimant allegedly put earpiece in his ear, and when claimant allegedly was standing against the iron beams, which he was lifting and shifting? What did the supervisor do to prevent claimant from doing such? By the case law authority of Kolawole and another, the Zakin Bogun citation is 2023 decision of the Apex Court, of the Court of Appeal. Ojo Jesse at pages 36 to 37, paragraphs A to B, held that where in an action founded on negligence, a defendant pleads contributory negligence, it would amount to a tacit acceptance of negligence on his part and relieve the claimant of the burden of establishing negligence on the part of the defendant. This is because by pleading contributory negligence, the defendant is simply saying, yes, I am negligent, but the claimant also contributed to the injury or damage which is suffered as a result of my negligent act, unquote. Now, in this case, by the tacit admission that the defendant is negligent in causing the injury to the claimant hearing, the burden now shifts from where there was indeed negligence on the part of the defendant to whether the claimant has indeed contributed to the occurrence to the cause of the injury or damage which resulted as a result of a defendant's negligent act. In other words, the burden shifts to the defendant to establish that the claimant had indeed contributed to the negligence. Ololo and Nigeria Agip Company Limited and another citation. See Ololo and Nigeria Agip Company Limited and another citation provided. I'm afraid it is apparent from all stated herein before that the defendant has failed woefully to establish or substantiate that the claimant indeed contributed to his injury. I find from the circumstances of this case that howsoever one looks at it, whether from the point of view of the claimant that it was the beams negligently placed by some co-employees that injured him, or from the point of view of the defendant that it was claimant that caused his own injury himself, it is clear that the defendant was negligent and thus breached the duty of care owed to claimant resulting in his injury. The fact that the defendant tendered evidence to show that it catered for claimant's hospital bills does not in any way affect the liability of the defendant for breach of his duty of care, I so hold. Did the claimant suffer any damage as a result of the breach of the duty of care? I find from the evidence before this court, and both parties are evident, that claimant was injured at work on the 14th of March 2022. In fact, the gory site of the injury is shown by some pictures in the bundle of pictures marked as Exhibit B3. In essence, the fact of the injury and that same occurred in the course of work is not in doubt. It is therefore clear that claimant has established that defendant was negligent in such a way that caused him the injury or damage. See the case of Mufutao and Adeniyi citation captured. It is in the light of this that I find that really one succeeds. The question then is, can one say claimant is entitled to any form of compensation for the injury suffered by him? I'm mindful of the content of Exhibit C1 relied on by the defendant, which allegedly shows that claimant has waived any right he has against the defendant. I've even perused the said document. It is worthy of note that claimant has denied making such. The same was a fabrication as stated in paragraph 18 of his additional sworn deposition. In essence, claimant is denying his thumb impression on the said Exhibit C1. I've herein before found that the thumb impression is equally a signature, but whether or not the thumb impression on Exhibit C1 is that of a claimant is another issue entirely. The position of the law is settled in resolving the issue of due execution of a document where the alleged maker denies a signature. The cause or option open to the court will be the following: one, to receive evidence from the attesting magistrate if there is such an attestation, and if it is still possible to call the magistrate. Two, to hear evidence from the person familiar with the signature of the alleged signatory or who saw him write the signature. Three, to compare the signature admitted by the alleged signatory to be his own with the one under contention under Section 101 of the Evidence Act 2011 as amended. See also the case of Amadi and Orisakwe and other citation captured, Nabule and Sanya, citation provided, Adenle and Olude, citation provided. DW3, by his written deposition, testified that claimant was the one who signed the document as he was there when claimant signed same, and he even witnessed same. Like I said, I perused the said Exhibit C1 and found that DW3, John Emmanuel, was one of those who attested the document on behalf of the defendant, and his signature therein is regular with the one on his written statement deposition at page 146 of the record of this court, which means that it was truly a witness to the said Exhibit C1. Now, in the American case of Veles versus Crane and Clark Lumber Corporation, citation provided, the court refused to uphold waiver of tort liability in an action brought by an employee. In that case, the court held that disclaimer, which was effective between employer and supplier of a defective scaffolding, would not preclude an injured employee from bringing an action under tort of negligence against the supplier. In the English case of Griffiths and L. of Dudley, citation provided, the Queen's Bench seems to have held that such bargains between employer and employees, which is not a naked bargain, but one supported by consideration will be valid. In that case, the consideration for the waiver of employer's liability by the employees under tort of negligence is if the employer continues to contribute the benefit association or club set up by the employee, which was equal to the employee's contribution. As the years went by, the disposition of English judges changed towards such waiver of liability or exemption of liability clauses. This brought about the restrictive interpretation of exemption and waiver of liability clauses, whether between the employers and employees or between other parties. In the English case of Alderslade and Henson Laundry Limited citation captured, Lord Green, MR, was quoted as saying, I quote, "Where the head of damage in respect of which limitation of liability is sought to be imposed by such a clause is one which rests on negligence and nothing else, the clause must be construed as extending to that head of damages, because if it were not so construed, it would lack subject matters. Where, on the other hand, the head of damages may be based on some grounds other than that of negligence, the general principle is that the clause must be confined to laws occurring through that other cause, to the exclusion of laws arising through negligence. The reason for that is that if a contracting party wishes in such a case to limit its liability in respect of negligence, he must do so in clear terms. And in the absence of such other terms and clause is to be construed as relating to a different kind of liability and not liability based on negligence, unquote. See also the South African case of Essa and Divaris. In giving effect to such clauses or agreement, the status and relationship of parties is relevant to determination of what the intention, knowledge, and expectation of the person to whom the exclusion of liability clause was addressed. This is because, according to Buckley LG, in the case of Gills Pye Brothers and Company Limited versus Roy Bowles Transport Limited, it's also an English case. It is inherently improbable that one party to the contract should intend to absolve the other party from consequence of the latter's own negligence, unquote. In the instant case, the head of damage suffered by claimant is not only limited to negligence, it can also be suited under Employees' Compensation Act or under breach of contract. It then means that the court cannot interpret that claimant sought to exclude the liability of a defendant in negligence in the absence of express words to that effect. I have to travel to Singapore, wherein in the Singapore case of Mr. Azim Muda and Hiap Tong Train and Transport, held that the employer's defense that he has signed a waiver agreement with claimant on the 4th of May 2018 was not tenable. The court found that such waiver to be valid had to have consideration in support and that the sum of 1,300 USD paid to the employee to sign the waiver agreement by the defendant representative did not serve as consideration, as same is not good consideration for giving up his right of action. That is not, sorry, I'll take that again. The court found that such waiver to be valid had to have consideration in support, and that the sum of 1,300 USD paid to the employee to sign the waiver agreement by the defendant representative did not serve as consideration, as same is not good consideration for giving up his right of action. The court also held that the fact that the employee will be allowed to continue work after he was well was too uncertain to be enforced as a term of a waiver agreement, as it is a statement of intention which has no contractual effect and cannot constitute good consideration. With respect to the instant case, in my respectful view, I do not think Exhibit C1, even though made by claimant, could exculpate the defendant from liability from breach of their duty of care.
That's correct, please.
I say so in view of the fact that claimant may have made the said Exhibit C1 only because he does not want to lose his only means of livelihood, since the defendant was still his employer. In such a case, it is the employee's quote and unquote poverty and not his quote and unquote will, which consented to such documents saying he does not have a claim against the defendant. It is in my firm view, which is rooted in the facts and evidence before this court, that the claimant could not have intentionally and voluntarily surrendered or relinquished his right to a claim. The claimant was still under the grip of a defendant as his employer, so he could be made to do anything in order to retain his means of livelihood. The defendant has to strictly show that it did not influence the making of Exhibit C1 in any way, especially as Exhibit C1 will be against public policy because of the disparity in bargaining powers between the two, as it is the policy of the law to protect employees or workmen against improvident bargain. In fact, the court per INI CJ, in the case of Morrison and Angelo Deep Gold Miles citation provided, had this to say as regard public policy in respect of waiver clauses, I quote, "Now, it is a general principle that a man contracting without duress, without fraud, and understanding what he does, may freely waive any of his rights. There are certain exceptions to that rule, and certainly the law will not recognize any arrangement which is contrary to public policy," unquote.
Let's go.
In Nigeria, this public policy protecting employees against improvident bargain is expressly stated via Section 13 of the Employees Compensation Act 2010, which provides those, and I quote, "No employee shall agree with his employer, waive or to forego any benefit or right to compensation to which the employee or the defendant are or may become entitled under this act." And please mute your phone. Please mute your phone. Any agreement in whatever form between the employer and the employee in contravention of subsection 1 of this section shall be void and unenforceable, unquote. Besides, the defendant in this case has not shown that Exhibit C1 was backed by any valuable consideration, especially in this case, where claimant was relieved of his employment shortly after then. It is in view of all the above that I discountenance with the argument of the defendant on Exhibit C1, which sought to waive the defendant's liability and find the defendant liable. Claimant by Relief 2, in his general form of complaint, seeks for an order of this court awarding the sum of 50 million naira as compensation for the permanent incapacitation, continual emotional and psychological trauma suffered by him. I've earlier found that the defendant breached its duty of care to the claimant. Section 19D of the National Industrial Quota Act 2006 empowers this court to award compensation or damages in any circumstance contemplated by the Act or an act of the National Assembly dealing with any matter in which this court has jurisdiction to hear. According to Section 254C1B of the Factories Act, is one of such acts which was made by the National Assembly, which this court has jurisdiction to apply. I've reasoned supra that the defendant breached its duty under the Factories Act. In awarding damages for the tort of negligence, two main factors have to be taken into consideration in assessing damages in cases of liability. These are financial loss resulting from injury, the personal injury involving not only pain and suffering, but also loss of the pleasure of life and loss of further endings. See the case of Kolawole and another, and Akimbogun Supra, Mufutawa and Adeni Supra, Ebe and Inamani citation captured, Odiagbonya and Dumes Nigeria Limited citation captured. The law is equally settled that a person injured by another's wrong, as in this case, is entitled to general damages for non-pecuniary loss, such as pain and suffering and loss of amenity and enjoyment of life. This may include a substantial sum for mental agony due to the fact that the quality of a person's life has been severely compromised. There's therefore no doubt that damages for personal injury can be awarded for permanent scarring or disfigurement, although there is no clear-cut principle for the quantum for the award of such damages. See the cases of Bello and Dada and another citation provided, Irerio Vo and SCC Nigeria Limited citation provided. The court in determining this will most times consider the awards made by courts in similar cases in same jurisdiction or in other jurisdictions where similar socioeconomic and industrial conditions exist. See the case of Kenneth Igosewe and Delta Steel Company Limited citation provided. The courts have been enjoined to consider the biting effect of inflation and consistent depreciation of the value of the naira, which is obvious to all, and thus should bear in mind the purchasing power of naira at the material time of judgment. See Oyewumi and SCC, Nigeria Limited Supra. We are in 2024, where the value of the Nigerian naira or the purchasing power has been reduced. I have at the back of my mind, I bear at the back of my mind, going by the content of the pictures in Exhibit B3, as to the current state of claimant's leg. Claimant has not suffered a permanent incapacitation on his leg, though he has to live with a scare on his heels for life, which undoubtedly will affect the quality of his life and his productivity. It is in view of this that I find that claimant is entitled to an award of compensation for the permanent scarring on his leg resulting from the injury sustained due to the negligence of the defendant. Consequently, I award the sum of 3.5 million naira as damages to the claimant. I so award. Claimant by his relief 3 is asking for the cost of 516,000 naira, special damages being the cost of his medical treatment and drugs bought by him from 1st of June 2022 to 1st of December 2022. The law has shown in plethora of cases is that a claim in special damages must be specifically pleaded and strictly proved. This means full particulars of the items have to be given in the pleadings and evidence led in proof of each item or each of the particulars of the item or items given. Unlike an award of general damages, special damages is not based on the discretion of the court, but on credible evidence that is before the court, which strictly prove the claimant's entitlement to the award. See the cases of Passmark Services Nigeria Limited and FBN, citation provided, Ajigbo Tosho and RCC, citation provided. First, claimant in this case did not plead the particulars of the sum of 516,000 is claiming as cost of drugs and medical treatment bought by him. He did not plead distinctively how he came by the quantum of that sum. Paragraph 29 of his statement of facts is, in my view, not sufficient for specifically pleading how he came by the quantum of the sums claimed. I'm not unmindful of the issues thrown up in this case between parties, whether the defendant paid for the medical expense of claimant after he sustained the injury. According to claimant in his pleadings and evidence before this court, the defendant bore the expenses of his medical treatment from the injury sustained for a while before he was left alone to bear the remaining costs. Exhibit B4 cannot sustain the above claim of the claimant in the absence of a specific pleading of how claimant came by the quantum of the sum claimed, as I've stated earlier. Besides, the cumulative of the sums covered by the receipt in Exhibit B4 is more than the sum claimed as special damages in this case. In essence, from the pleadings of the claimant, the said sum claimed as special damages was not pleaded and with particularity and was not also strictly proved to entitle the claimant to the award of same. It is in consequence that I find that relief 3 is not grantable and thus fails. Claimant is claiming for the sum of 5 million naira as cause of action. In the case of Kapa and Alberto versus NDIC citation provided, the Apex Court held that a successful party is entitled to costs which it should not be denied, except for good reason. See also the cases of First Bank and Oronsanye, citation captured, Mekuye and Emirates Airlines, citation provided. Also, the rules of this court, particularly Order 55, empowers this court to grant cause of action at its discretion. The discretionary power of the court is to be exercised, though judicially and judiciously. Claimant in this case, including his counsel, were in court most of the times of sitting. Neither did he misbehave or misconduct himself throughout the trial. The claimant in the instant suit has succeeded in the most part of his claims. I therefore find it just that I exercise my discretion in his favor. Accordingly, I award the sum of 1 million naira as cause of action in this suit. In relief 5, claimant is claiming the sum of, is claiming 10% Sorry, I'll take that again. In Relief 5, claimant is claiming 30% quarterly interest on total judgment until judgment sum is finally liquidated. There is no doubt that what claimant seeks by its relief, this relief, is post-judgment interest. The position of the law is clear as regards the award of post-judgment interest. It is tried that post-judgment interest may be awarded even where it was not pleaded because it is statutory and is at the discretion of the court. So the case of Femicia and EcoBank, citation provided. However, the rules of court regulates the discretion of the court by setting the rate or percentage at which such post-judgment interest may be awarded. In the case of Bolanley and Access Bank, PLC, citation provided, the Court of Appeal held that the power of this court to grant post-judgment interest is statutory, as it derives its root from the rules of this court, and that this court, as a trial court in that case, derives such powers from the National Industrial Court rules. This court is empowered by the provision of Order 47, Rule 7 of the rules of this court as captured in Bolanley and Access Bank Supra to grant post-judgment interest at a rate not less than 10% per annum. This means that claimant cannot be asking for quarterly interest as he did. However, he is nonetheless entitled to post-judgment interest in respect of the monetary sum already awarded in his favor. I therefore exercise my discretion in favor of the claimant by awarding 10% interest on the judgment sum, 10% simple interest on the judgment sum per annum. Relief 5 does succeed to that extent. In sum, I find that claimant's actions succeed in the most part. I declare an order in favor of the claimant against the defendant as follows. 1, that claimant is entitled to be paid the sum of 3.5 million naira as damages for the negligence of the defendant resulting in the permanent scarring suffered by claimant in the course of employment. 2, claimant is entitled to the sum of 1 million naira as cost of action. And 3, the damages awarded as well as the cost should be paid within 30 days from the delivery of this judgment, failure of which it shall attract 10% simple interest per annum. Judgment is accordingly entered.
As court pleases. My Lord, we are most grateful for a well-considered judgment. We have learned so much from the court this morning, and I'm grateful to the court, sir.
Very well.
My Lord, I want to personally appreciate my Lord for exposing my mind beyond this very case. My Lord, have gone beyond our jurisdiction to ensure that justice is done. Indeed, my Lord, have displayed that a common man can only get justice from court. It is in view of this, my Lord, we sincerely appreciate you, and we pray that may the wisdom of my Lord be preserved. And we are equally hoping and looking unto God that in a very short time from now, my Lord will be delivering judgment from the Court of Appeal and down to Supreme Court. We are most grateful, my Lord. Thank you, my Lord. Yes, my Lord.
So a clean copy will be forwarded to you in Lokoja. I observed some very little typos, so I will correct them and forward clean copies to you.
As court pleases.
Very well.
Most grateful to the honorable person.
Very well. I rise.